My name is Parks White. I went to Clemson University. I graduated in 1997 and went to work for a software company for a few years. I didn't really like it, so I decided to go to law school, hoping to be an FBI agent. I got into law school thinking I wouldn't enjoy the law at all. Turned out I really loved it. Finished at Alabama in 2003 and moved back to Hartwell, Georgia, where my family is from, and studied for the bar there. I passed the bar in 2003 and couldn't get a job at the local DA's office in the Northern Circuit, so I went down to Augusta, where I worked for Danny Craig, who was the DA there. Danny let his assistants, who seemed to know what they're doing, handle a lot of really complicated and big cases early on. So 2 months after passing the bar, my first trial was a vehicular homicide. I got a guilty verdict, and it was amazing, and I loved it. And I was completely addicted. So in 3.5 years in Danny's office, I handled over 700 felony cases, and I tried about 46 trials. In 2007, I joined the Navy as a JAG and went on active duty. The year before I joined the Navy, I tried 5 murder cases and got guilty verdicts in all of them. If I tried one more, I would have had the office record for most murders in a year. I joined the Navy, went on active duty to serve with sailors, Marines, and Coast Guardsmen. While on the Navy, my first year, I did 100 wills and 300 tax returns and tried one case. Not really the same kind of demand in the Navy for trial work as there is in the civilian world. But in 2010, I had the opportunity to deploy to Iraq, where I worked with the Law and Order Task Force. I was the embedded liaison with our Special Forces client in the northern part of the country. While they were doing operations, continuing to pick up bad guys and exploit them for intelligence, my job was to refer them into prosecution in the Iraqi system. It was a really great experience, and I got to meet a lot of amazing people and work on some pretty interesting stuff. In 2011, I separated from active duty and went back to the DA's office in Augusta. Over the course of next year, I tried 11 jury trials, got guilty verdicts in all, tried 2 murders back-to-back in 2 weeks, got guilty verdicts in those. And then last year, I decided that I wanted to come back to where I'm from, my family's from. So I ran against the 16-year incumbent, and we won in the primary, and I did not face opposition in the general election. And I took over in January as the district attorney of the Northern Judicial Circuit. It's been a very interesting experience. I've come to learn that being an assistant district attorney is the best job in the world. Being the district attorney has a lot more responsibility, and there's a lot more things that go along with it. But it's been very rewarding. I'm very happy to be here and to get to speak to you today about the DA's office. So, the office of the district attorney is just like Law and Order with way more paperwork and no scotch. So the mission of the district attorney is to uphold the United States Constitution first and foremost. We all take that oath. The Constitution of the state of Georgia and the laws of the state of Georgia, to preserve the safety of the public and to protect the rights of crime victims and pursue justice for all citizens with skill, honor, and integrity. Our goal is to provide fair, effective, and expeditious prosecution of crimes, both misdemeanors and felonies. There are a lot of DA's offices around the state that handle only felony cases. The allocation of resources is to prosecute misdemeanors is assigned to what's called a solicitor general. But in our circuit, my circuit, we handle misdemeanors and felonies for all 5 counties except for Elbert County, which has a state court. I'll get into that as well. We're also the legal advisor to all law enforcement in the circuit. So when they have an issue, a question about in the investigation of a case, they refer to us. I'm on call 24/7. I get calls throughout the day and throughout the night asking me questions about search warrants, about investigations, about when they can question someone and when they can't. And that's part of our responsibility is to be there for them. We're also responsible for training them, to inform them of changes in case law. Just a couple years ago, I think it was maybe a year and a half ago, there was a case that changed Miranda entirely, that allowed for when a person had been questioned by law enforcement and they invoked their right to counsel, that historically that meant you don't get to go back and talk to them, they have to approach you. But the Supreme Court case said that after 2 weeks, if they're not in custody, you can go back and re-interview them if they have not obtained an attorney and question them again. A lot of law enforcement didn't know that in the area that we're prosecuting because they were not constantly providing them with updates in case law. But that's part of our job, and that's what we're doing. We've had training with all the law enforcement agencies in our 5 counties since I've taken over. So in broader terms, we're the representative of the state of Georgia in all cases arriving in Superior Court. We have broad discretion in the resolution of all matters, and that's where we're going to get talking to what plea bargains are and with regard to a few other things. I have no supervisory authority other than the citizens of my circuit every 4 years. So the Attorney General doesn't oversee my office or my position. My position has no supervisor other than the citizens. So these are the 49 judicial circuits in the state of Georgia. So there are 49 district attorneys, and this is the northern covering Elbert, Franklin, Hart, Madison, and Oglethorpe. Pretty large area of land there. We are authorized to dismiss warrants as a DA. So as soon as it arrives in our office, we have the ability to just, without the approval of a magistrate, without the approval of a judge, we can write a dismissal of a warrant, tender it to the court, and the warrant goes away. We can take matters dismissed at preliminary hearing to grand jury for indictment. So you're all, I'm sure, being in criminal justice, have learned something about the procedure, that once a warrant is issued by a magistrate, if a person is in custody and not been indicted, they have the opportunity to go before what's called a preliminary hearing from the magistrate. At that preliminary hearing, the state presents evidence. Hearsay is admissible. Primarily, we just use the lead investigator, put him on the stand for the magistrate to determine whether or not probable cause exists. If the magistrate dismisses a warrant, it has no bearing or effect on our office. We can still take the matter forward to grand jury for indictment. When we do that, we then issue a grand jury arrest warrant and have the person picked up again. We can pursue the death penalty where aggravating factors apply for murder cases, and we can deal or refuse to deal. However, we're not merely the advocate for one side. That's a big part of our responsibility as well. We are bound by the rules of professional responsibility in the United States Constitution to only prosecute those we truly believe are guilty. In a case called Berger versus the United States in 1935, Justice George Sutherland said, the prosecutor is not merely the representative of an ordinary party to a controversy, but of a sovereignty whose obligation to govern impartially is as compelling as its obligation to govern at all, whose interest in a criminal case, therefore, is not that he shall win, but that justice shall be done. He is in a very peculiar, as such, he is in a peculiar and very definite sense the servant of the law, the twofold aim of which is that guilt shall not escape or innocence suffer. He may prosecute with earnestness and vigor, indeed he should do so, but while he may strike hard blows, he is not at liberty to strike foul ones. It is as much his duty to refrain from improper methods calculated to produce a wrongful conviction as it is to use every legitimate means to bring about a just one. This is on my wall, and I want to have all my ADAs have this on their wall as well, because I want them all to remember that our duty is not to just merely be an advocate for one side and to pursue people and try to just railroad anybody. We should never do that. My greatest fear is putting an innocent man in prison. Our obligation is to the accused as well as to the public to make sure that we will never prosecute or send anyone who is innocent to prison. So, if we believe everyone is guilty, why do we bargain? Plea bargaining. There's simply no way we can afford everyone the right to trial. And that's the hard and simple truth, is that if everyone were given the opportunity to have their case go before a jury, we would end up in a system that would come to a grinding halt and would never be able to function at all. We'd have cases backed up for decades. In 2013, so far this year, we have tried 19 cases in my circuit to a jury. We've gotten guilty verdicts on all but one. There was one where I believe they found him not guilty of the drug offense, but guilty of the open container. So we essentially lost that one. 7 cases tried to a judge alone, in which is called a bench trial. And we've closed 2,362 cases to date. So you can see that if we had tried 2,362 cases, we'd be in a situation where that's not even possible. We only have 3 Superior Court judges. I have 5 assistant district attorneys. It just isn't possible to give that many people their right to a jury trial. So how do we plea bargain? Well, first we consider the defendant's criminal history. If someone is a first offender, we want to give them consideration for that fact. The fact that they have no criminal history always weighs in significantly to our decision and how to resolve a case. We consider the nature of the offense. Is it violent? Does it involve drugs, property, or burglary? Now, all these have different considerations, because violent crime, obviously, that's the kind of thing that we want to focus on primarily. Make sure that we hold those people who would hurt others accountable and prevent them from doing it in the future, and make sure they're not emboldened by the system. A slap on the wrist for a violent offender sends a message to them that there are no consequences for their actions. In recent years, we've seen changes in the way we've approached the prosecution of drug addiction, not necessarily dealing. We go after dealers, but drug addiction itself is something that can't necessarily be fixed by the prison system. It requires a change of mentality on the part of the user. Property, primarily what people who are victims of property crime want is their stuff back. They want restitution. They want us to be able to provide them with the ability to get their stuff back from the person who took it. And in order to do that, we have to afford someone the opportunity, rather than going to prison, to be on probation so they can work and make restitution, make the victim whole. And burglary is the kind of thing that even if it's your first offense, you need to be going to jail for some period of time because it's one of the most dangerous offenses in the state of Georgia. I mean, even if you don't use a weapon, going into someone's house, you pretty much have an absolute right to kill someone who enters your house without authority. The defensive habitation statute in Georgia is very powerful. If someone breaks in and you think that they may cause harm to anyone in the house, you're authorized to use deadly force. Other considerations are, can we find the victim and witnesses? And this seems like something that people don't in general think about, but by the time a case gets to us and we've taken it forward to indictment, it could be some months or even at certain times years down the road. Victims tend to be, not all the time, but many cases tend to be transient, not have fixed addresses or fixed telephone numbers, and we lose sight of them. It's hard to locate them and track them down. If we can't find a victim or a witness, we're not going to be able to prove our case. Because as you're aware, all those statements they gave to law enforcement during the course of the investigation, we can't just simply walk into court with the investigator and have them testify to all that. We have to have live testimony from the victim or witness. It's a requirement of the Sixth Amendment in the Confrontation Clause. Are there evidentiary issues? Can we prove it? Have we lost evidence because of a suppression issue? Are there other factors in determining whether or not we're actually going to be able to meet our burden, the highest burden known to law, of proof beyond a reasonable doubt? Is the victim interested in the outcome of the case? Many times we have situations where someone initially very much wants to see someone prosecuted. Down the road, they've moved on, they can't be troubled. In those kind of situations, it's hard to get them into court. And what do they want? And the flip side of the coin is that sometimes we don't care what the victim wants. And we can't care what the victim wants because the victim is not a party to the controversy. It's the state of Georgia versus the offender. So this is particularly important in cases of domestic violence. Someone who has a history of being a violent individual who abuses a woman, and in many cases, the victim doesn't want to see the person prosecuted any longer. Earlier this year, there was an individual in Hart County who had a case still pending from 2010. He had two girlfriends, and within a week, he had beaten one so badly that he broke her teeth, and the other one he left her with a black eye swollen to about out to here. So it was 2 counts of aggravated battery. He had 4 prior felony convictions. Neither victim wanted to see him prosecuted. Both victims had indicated that they wanted the case to go away. I think both of them had been engaging in sexual relations with him. We did not take their desires into consideration in determining the appropriate resolution for Mr. Gaines. Instead, we noticed him as a recidivist, and I'll talk about that a little later, what that means. We served both victims personally. We informed them if they failed to come to court, we would get witness attachment orders. We would hold them in jail until they were willing to testify. Mr. Gaines, seeing the writing on the wall, ultimately pled guilty to a recommendation of a 10-year sentence in prison without parole, followed by 10 years on probation. Do we need to make an example out of the defendant, send a message? And this is one of the situations, again, where, based upon the nature of the offense and the individual, their history, sometimes we have to make sure that what we do resonates in the criminal community, that they know we're coming after them. Because the more powerful that message resonates in the criminal community, the more likely they are not to engage in criminal conduct in my circuit. So, for example, this is where we get into some things that sometimes seem like inequities, because Mr. Brewer, possession of cocaine with intent to distribute, earlier this year was sentenced to 3 years in prison. It was his first felony offense. He was paroled in May. That was January. But based on Mr. Brewer's lack of criminal history, a 3-year prison sentence followed by probation seemed appropriate for possession of cocaine with intent to distribute. Mr. Newton had 6 prior felony convictions and was a notorious drug dealer in Hart County. So Mr. Newton's best offer that he received after he was noticed as a recidivist for his new offense of possession of cocaine was a recommendation of a life sentence if he pled guilty. And that is what he received. See at the bottom. Maximum possible release date, life. So will prison deter the behavior? That's another factor that we take into consideration. Drug addiction, prison doesn't really deter drug addiction. People come out of prison, if they don't receive treatment, they're going to be right back on oxycodone or whatever that their drug of choice is. But the Residential Substance Abuse Treatment Program administered by the Department of Corrections is very effective at breaking the cycle of drug addiction. General population is not so much. Is there jury appeal to the case? And that's another factor that we take into consideration when determining whether or not to take a case forward. And this it seems like something that this is a difficult thing to learn, and it's really getting into the weeds of prosecuting cases. But there have been psychological studies that have shown that the closer connected the two parties are, the victim and the offender, the less likely a jury is going to care. And the reason for it is that juries have a hard time putting themselves in the shoes of a victim if those parties are closely related, because they can't see someone that they know in their circle of friends and family members acting that way. But when it's stranger on stranger, it's a completely different situation, because every juror can identify with a stranger victim. And it just means that they're the same as they are. Out in the community, a stranger comes along and impacts their life in a negative way. Does that make sense? And I encourage everyone to ask questions as we're going along. This isn't meant to just be a lecture. If you have anything, just please interrupt, raise your hand, go ahead and ask. Another reason for plea bargaining is the fact that we have limited resources. My circuit covers 5 counties with a population of approximately 110,000 people. We handle all felonies and misdemeanors except the misdemeanors in Elbert County, which is a state court. I have 5 assistant district attorneys. So we have a caseload in excess of 500 cases. We just simply cannot try everything. In addition to that, trials are expensive. A guilty plea takes about 15 to 30 minutes total to actually get someone resolved, the case resolved, the conviction in place, and the sentence begins. A jury trial can take weeks, sometimes they can take months. And every day that you're in there, every juror on that panel is being paid between $25 and $50. I know it seems like small potatoes, but these counties that I'm the district attorney over have very limited resources. They're very poor counties. They're rural counties. So when we have a lengthy jury trial, that's going to be an expensive proposition for the county itself. But obviously, there are circumstances where we have to go forward, and that can't be a consideration. But in general, for minor offenses or relatively minor offenses, using up those county resources doesn't make a lot of sense. And it's another factor that we use in determining the appropriate sentence, is that we offer someone a deal. We want to make it clear that we're going to want more after trial. And we refer to that colloquially as a fair trial tax. Ostensibly, the idea is that no one should be punished more severely for going to trial, correct? Would everyone agree with that proposition? But in the same token, no one who goes to trial and is convicted by a jury is entitled to the consideration that a person who accepts responsibility should receive for accepting responsibility and pleading guilty. So it's not that they're being punished more severely, it's that we're giving them consideration for accepting responsibility. So when don't we do it? Because not every case should be pled. Not every case should be resolved by a plea bargain. Many times we have to resolve cases through using a jury trial because we want to send a message. This is an accident on Highway 17 in Franklin County. The vehicle on the right was driven by the offender. The vehicle on the left was driven by a 79-year-old woman who lost her spleen. Her husband was the passenger of the vehicle, and he was killed. What you can't see in the picture is the other Chevy Silverado that's off of the screen to the left. That left the roadway and resulted in the death of a resident of Madison County who had 2 sons who were getting ready to go, or one was in college, one was getting ready to start college, and a daughter. No deals. This is the driver of the vehicle, Buick LeSabre. Mr. Dixon had 5 prior DUI, drug, and alcohol arrests. This has all happened before I took office, and the incident actually took place in April of 2012. 3 were dismissed without any real good reason that I could find in the record. His last DUI conviction was in the 80s, and his last arrest before this incident was 1 month prior to this incident, where he was arrested for driving under a very similar cocktail of drugs. So in April 2012, he drove under the influence of methadone, diazepam, alprazolam, marijuana, and a BAC of .083, 1.5 hours after the crash. All of this was by 3 o'clock in the afternoon in April of 2012. Crossed center line Highway 17, killed 2 people and seriously injured a third. That's his car. So in Mr. Dixon's case, we didn't offer him anything. The offer was plead guilty to the indictment or go to trial, and we will recommend the maximum even if you plead guilty. He went to trial. He was found guilty in 35 minutes. He received 50 years in prison, and hopefully he'll never drive a car on the streets of Georgia again. So let's talk about sentencing enhancements and some mandatory minimums in the state of Georgia, or how no deals can instill the fear of God in a criminal. Georgia has a series of recidivist provisions and mandatory minimums. They are powerful arrows in a prosecutor's quiver. And I was surprised to learn that the assistant district attorneys that were working in my circuit when I took over were unaware of these statutes and how they can be used to our advantage to encourage someone to plead guilty or you just take them to trial. First, let's talk about serious violent offenses under the OCGA 1710-6.1. These are also known as the 7 deadly sins in the state of Georgia. They are murder, armed robbery, kidnapping, rape, aggravated child molestation, aggravated sodomy, and aggravated sexual battery. The penalties for murder are life, life without parole, or death. Those are only 3 possible sentences in the state of Georgia. Armed robbery is a mandatory minimum of 10 years in prison without parole and a maximum penalty of life. Kidnapping is also 10 to 20-year life. Rape is a 25-year minimum. And even if the judge imposes a split sentence where he imposes the minimum of 25 years, the balance, you will serve life on probation after that. Aggravated child molestation also has a 25-year minimum. Aggravated sodomy has a 25-year minimum. And aggravated sexual battery has a 25-year minimum. These are big minimums. And if you compare this, as a service member, there are no minimums for offenses in many cases. I was a defense attorney in the Navy. I didn't ask to be a defense attorney. I was assigned to be a defense attorney. I defended a sailor at a court-martial who was accused of engaging in indecent liberties with a 12-year-old girl. He was found guilty at trial. He received a sentence of 36 days restriction without confinement. So life sentence for a serious violent felon means a minimum of 30 years in prison before parole eligibility. That increased, I believe, in 2006. It was previously 14 years. In the 80s, it was 7 years. Consecutive life sentences means 6 years before parole eligibility. And if you're sentenced to a term of years for armed robbery or any of the serious violent felonies, you're not eligible for parole for whatever term of years you're sentenced for. So, for example, we recently had a gentleman named Kebron Brock over in Franklin County who was indicted for a number of burglaries. While I was out on bond for those burglaries, he and several other individuals engaged in a home invasion armed robbery of a 70-year-old man where they shot him in his house and took his wallet. We didn't offer Mr. Brock anything. Actually, I'm sorry, we did. We offered him 20 years to serve for armed robbery and followed by 20 years on probation. He accepted the deal rather than go to trial, and he's now doing 20 years to the door. So he will not be eligible for parole during that 20-year prison sentence. And a second conviction for a serious violent felony in Georgia, that's any one of those 7 deadly sins, is a sentence to life without parole. In addition, individuals are adults for the purposes of prosecution in Superior Court at the age of 13 for serious violent felonies. So one of the 7 deadlies, Superior Court has original and exclusive jurisdiction over that offense. It can be transferred under certain circumstances to juvenile court with the approval of the district attorney. The same penalties apply except for death. So this is Lovey Edwards. Mr. Edwards, at the age of 15, well, let's get into that. Mr. Edwards, at the age of 15, had an argument with the sister of his best friend out in front of a house where a group of kids were playing. The 16-year-old victim slapped Mr. Edwards in the face. He pulled a .25 caliber handgun from his waist and shot her in the chest once. She turned around and stumbled and collapsed, and he shot her again and then ran away. She was 7 months pregnant. They delivered her child via emergency cesarean section. The child lived outside the womb for 30 minutes and then perished. Her family didn't know she was pregnant. So Mr. Edwards went to trial. He was convicted of 2 counts of murder. He received 2 consecutive life sentences. He'll be eligible for parole at 75. His conviction was affirmed by the Supreme Court of Georgia earlier this year. So in addition to the mandatory minimums that we have in the state of Georgia, we also have a series of what are called recidivist punishment statutes. We don't have the same thing as like California where 3 strikes and you get a life sentence and you're done. We have something similar. OCGA 1710-7A and OCGA 1710-7C, these are those powerful powerful arrows I was discussing. So, Official Code of Georgia annotated 1710-7A says, any person who after being convicted of a felony offense in this state or a felony offense in another state commits a felony punishable by confinement in a penal institution shall be sentenced to undergo the longest period of time prescribed for the punishment of the subsequent offense for which he or she stands convicted. So you have 1 felony conviction, you get a new felony charge. If the prosecutor provides notice of intent to punish under this code section, then the judge must impose the maximum for the next offense. Now the judge can split that though. So let's see. So an example, defendant has a conviction for felony theft by shoplifting from 8 years ago. He commits an armed robbery. Prosecutor files notice of intent to seek recidivist punishment under 1710-7A. He's convicted at trial. Going back to those other slides, what is his sentence? Does anyone remember? Maximum for armed robbery? It's life. And a life sentence can't be split. So a prosecutor files notice under this subsection and refuses to deal can actually take him off the street for 30 years. To compare, if someone had like a shoplifting conviction from 8 years ago and they committed an aggravated assault, he would have to receive a maximum sentence of 20 years, but the judge can split that any way he wants, meaning he can impose 5 years in confinement followed by the balance on probation, 15 years, but it has to be a 20-year sentence. And under 1710-7C, any person who after been convicted under the laws of the state for 3 felonies commits a felony shall, upon conviction for the 4th offense or for a subsequent offense, serve the maximum time provided in the sentence of the judge based upon such conviction and shall not be eligible for parole until the maximum has been served. So that means that whatever portion that the judge orders in confinement, the parole board has to ignore them. They're not allowed to let them out early. So let's imagine another scenario where prosecutors file notice to punish under 1710-7A and 1710-7C. The defendant has 6 felony convictions, burglary, theft by taking, and 3 forgeries. He commits a burglary in the first degree, which is burglarizing a dwelling or someone's home. Prosecutor files notice of intent to seek recidivist punishment. He's convicted at trial. His sentence is 20 years. And whatever the judge orders in confinement cannot be paroled. So if he splits it 10 in, 10 out, he's in for 10. If he orders 20 years in confinement, he does every day to the door. So let's look at another example of how powerful these 2 sections working together, particularly with serious violent offenses, can be. Mr. Louis Leroy Odom had 7 prior felony convictions. He was in a halfway house, meaning he was about to be released on parole. He was 1 month from being returned to society. He walked away from the halfway house and commits a new offense. So let's review the evidence against Mr. Louis Leroy Odom in the case involving the Shell station. This is a video from the Shell station. It really depends on the convenience store, but a lot of these videos can be of pretty poor quality. But Mr. Odom matches the description perfectly of the person who committed the armed robbery with a object that appeared to be a gun under his shirt and a black mask over his face. The description was a white male, short cropped hair, white t-shirt, blue jean shorts, and a gun under his shirt. So that's Mr. Odom, captured the same day, about 300 yards from the Shell station. Located 300 yards from store, had a shell bag containing $70 in his back pocket. These are the bags used to deliver the cash, and that was the bag in Mr. Odom's back pocket. He had a his gun was located in another pocket, and this was his weapon. It was a crest box wrapped in a black cloth under his shirt. Now, in Georgia, you commit armed robbery whenever you either use an offensive weapon or any article, replica, or device that has the appearance of an offensive weapon. It doesn't actually have to be a gun. If you want someone to believe it's a gun for the purposes of the code. He also had a crease in his shirt, which you'll notice the way the individual in the video is holding his toothpaste box gun, and the way that just hours later Mr. Odom still had the crease in his shirt. And so when Mr. Odom was brought in for questioning, he indicated to the investigator that he didn't want to answer any questions. He just wanted to know one thing. Why am I being charged with armed robbery when I didn't have a gun? So all this pretty much points to Mr. Odom's guilt. So, recidivist notice is filed. Mr. Odom refused the state's offer of 15 years in prison followed by probation. He had 7 prior felonies. Bear this in mind. This is a person who had no intention of ever returning to society in a meaningful way or contributing. Instead, he decided to go to trial, and toothpaste packing bandit gets life term. So Mr. Odom, because of 1710(7)(a), says that the maximum sentence he must receive is life. He received life. Because he's also noticed under 1710(7)(c), it means that the parole board can't consider him. So it's life without parole for a toothpaste box robbery of a convenience store. And folks, that's it. I know that was really fast. I think I only had 40 minutes of material there, but are there any questions?
Okay, well, Mark, do you ever consider when you're looking at taking plea bargains, when you look at the evidence, maybe you have enough to convict, but you know it's going to go to an appellate court because of the issues there? Would that ever come into play looking beyond the first trial to any issues that may come up in the plea?
That's another part of our responsibility as prosecutors is that defense attorneys, by and large, and I don't mean to discount their job, because their role is vitally important and as a restriction on the power of the state, making sure the Constitution is observed. But they go and they ask questions, and they don't care about muddying up the record. You know, if they want to make sure that they're not found to be ineffective. Sometimes some of them actually make it so that they ultimately will be found ineffective. But the good ones don't do that. But they aren't concerned with making sure the record is perfect. We have to be cognizant of the fact that not only are we trying to convince 12 people at a jury that the person is guilty, but we have to be thinking forward about when the appellate court reviews this case, is everything going to be sufficient? Have we proven it sufficiently? That they were reviewed for sufficiency of the evidence, and also reviewed for a number of other different factors. Like, for example, there was a case called Walker versus the state that recently came out of the Supreme Court. After an argument on the road, a road rage type situation, this husband and wife get out of their car and they go over to the other individual's vehicle, Walker's vehicle. Walker has an argument with both of them. The husband and wife then walk behind the van that is being driven by Mr. Walker. Mr. Walker shifted into reverse and backed up and ran over the wife, the victim. Drug her 90 feet down the road, leaving a large amount of flesh on the asphalt. She came loose from underneath the vehicle. He then shifted into drive, hit her again, drove off, dragging her another 100 feet in the opposite direction. He went home. He removed his license plate from his vehicle, tried to hide it, and went to trial. Now, the state and this is a case out of Cobb County. The state had indicted him for aggravated assault, for the weapon being the car, resulting in death, which so felony murder with the underlying felony being aggravated assault. They also indicted him for homicide by vehicle, with the underlying offense being reckless driving. Now, he was found guilty of both for the same death. Okay, reckless driving has a mens rea, or criminal intent, of criminal negligence. Aggravated assault requires criminal intent. It doesn't mean that you have to actually intend to commit the act. That's prohibited by law. I'm sorry, you don't have to intend to violate the law, but you have to intend to commit the act that is prescribed by law. Okay, so what the court said in that case, the Supreme Court of Georgia, is a 10-year-old case. They reversed it 2 weeks ago on the basis that he cannot have simultaneously have had criminal intent and criminal negligence at the same time. The court said that they were mutually exclusive verdicts, so they sent the whole thing down to be retried. So we have to always remain cognizant of those types of issues, make sure that we indict cases in such a way that ultimately the court won't review it and determine that a mutually exclusive verdict existed. And also, we will never try to take in evidence that we can't bring into trial. I mean, we're aggressive in terms of like noticing people for similar transactions and trying to get in additional evidence of other crimes that they might have committed if those other crimes show that they committed the crime that we're trying them for. In general, we're not allowed to introduce evidence of a person's bad character to show that they had a bad character and acted in conformity with the bad character on the occasion we're trying them for. But if they have very similar prior offenses, pre-trial we can notice the person that we intend to bring those in and use those. And so long as we do it correctly, we're not going to be reversed. But if we go off the rails and we argue that someone's prior burglary conviction shows they committed trafficking cocaine, that's not going to work. And an appellate court will look at that and say, no, that was improper evidence that was introduced to the jury, and as a result, the conviction has to be reversed. So we're always mindful of making sure that the evidence we use is the best and highest evidence and that it speaks the truth. Yes, sir.
Your district, you have several magistrates that are not graduates of accredited, I guess, lawyers or past the bar. Do you also advise with some of the magistrates in their cases or their courts?
Not on particular cases, because that would, obviously the requirement for both an arrest warrant and a search warrant is that they be issued by a detached and neutral magistrate. So we can't act as a legal advisor to them on particular cases. Like we can't suggest to them what they should do or how they should do it. But in general, if they have questions about the law, we will talk to them about just general matters. But if they came to us on a particular case and begin to ask us about what they should do or how they should do it, then that might violate that constitutional requirement for a detached and neutral magistrate. No questions, really? Yes, sir. Market forces? I mean, I agree, and we're coming along. But bear in mind how quickly technology has advanced over the last 20 years. I mean, the idea that a few years ago when Google introduced a Gmail service that provide gigs and gigs of space for free, everyone was flabbergasted by the idea. But cameras for the last 20 years have been getting better and better in convenience stores. But the software is often proprietary, one, so that even when they record all this stuff, it's hard for us to get it off. And then even when we get it off their server, we have to get their software in order to be able to use it as evidence down the road in trial. So it's this a number of different competing industries out there that have offering different services, the quality of service they offer, the price of the services they offer, how much is going to factor into the bottom line of the convenience store. Those are the kind of factors that are at play. There's no standardization, and it's up to the store. What are they really looking for? Do they want a camera there to act as a deterrent, or do they actually want a camera there because they want to help out down the road in the event that they're the victim of an armed robbery? Yes, ma'am. Those types of offenses typically start off in a lower court, like a municipal court or a probate court. If they refuse to resolve the case at that level and they demand the case be brought up, or if it's attendant to another offense, it could be brought up to Superior Court. But in general, we don't handle a lot of just underage drinking cases by themselves. But we do in circumstances when, for example, a person under the age of 21, does anyone know what the cutoff is for DUI for under 21? 0.02. And that's kind of a big deal because if we had an incident in Oglethorpe County earlier this month, I'm sorry, it was last month, where a student from UGA drove over, got confused on the roads, was intoxicated, drove over in Oglethorpe County, and was driving over 100 miles per hour through Lexington, left the roadway, and killed his passenger. Now, for the purposes of vehicular homicide, that's all we have to prove is he was over 0.02. Actually, in his circumstance, he wasn't. He was over 20. He was 22, but he was over 0.08. But if, for example, he had been 19 or 20, all we have to do is prove these over 0.02 in order to get a conviction for vehicular homicide. Yes, ma'am. Don't? No, I'm kidding. I don't like lawyers. And advice from an attorney: work as hard as you can to get into a state school. I went to University of Alabama, and when I went, my tuition was $2,500 a semester, and the University of Alabama now is like number 26 in the country. So it was relatively a bargain. Even at that rate, though, because I wasn't working during the time I was in law school, I incurred a lot of debt, and it can be a hard thing in today's market with the number of attorneys we have in this country to get past that debt unless you go to a really good school and get a degree that's going to allow you to become a part of a big firm or have a good job with the government. The United States has about 8% of the world's population, maybe not even that, maybe 5. It's not a huge percentage. We have more lawyers than the rest of the world put together. And over the last few years, in particular, as you know, there are restrictions on the AMA provides that only a certain number of people can graduate from medical school every year. There are no such restrictions for the bar. So we just have so many attorneys out there, and so many of them are struggling right now to make ends meet because of those factors. The market is saturated with lawyers right now. So my advice is to work as hard as you can to get a really high LSAT score, get into a good state school. Georgia's got an excellent program, and finish at the top of your class. Yes, ma'am? Did you have a question? These aren't universal. This is kind of getting into social psychology. So, the further you get down that scale of purity of science, the more fuzzy it gets. But, for example, the case where the young man drives into Oglethorpe County and kills his passenger. Now, a jury is going to have a harder time relating to that victim because they're going to think to themselves, I would never get in a car with a drunk driver. I just wouldn't do it. It's not a very smart thing to do. But you compare that to the case of the two individuals on Highway 17 who are just driving along when a drunk crosses the center line and kills them. In that situation, anyone can put themselves in the shoes of just being a motorist on the road when some person who's under the influence of a cocktail of drugs crosses the center line and kills you. And so they're going to identify more with that case than they would in a case where the victim is a passenger in the vehicle. Yes, sir.
In your circuit, how do the homicides, regular standard homicides, compare with particular homicides where you have alcohol involved, drug involved, or do you have something?
I don't have any hard statistics, but I know that we've had a surprisingly large number of homicides relatively this year in the circuit. But if you compare it to like someplace like Augusta, man, we'd have 40 murders a year in Augusta about. In the Northern Circuit, we have one unsolved in Franklin County from earlier this year. We have another that's pending. We have two that are pending. That we had one Elbert County a couple months ago, but not a whole lot of actual murders. We have had a number of vehicular homicides. It's a whole different mindset, obviously, of going intentionally murdering someone versus being grossly negligent and violating your standard of care and killing someone on the roads. That tends to happen a lot more often.
That one case you have pending on criminal justice, it's close to home for us. We see violence and stuff like that. How did you relate that with your prosecution on your domestic violence cases? What options are there to work with the victims?
Well, there are a number of really good programs in the circuit, including like Heart Haven that provides assistance to domestic violence victims. It's a difficult thing to balance the two competing factors because there are circumstances where someone may have been struck by their spouse for the first time. Spouse comes in, they don't want to testify, they don't want the case to go forward. The person has no criminal history, and they just don't want it to ever happen again. we can have a difficult time even at trial getting a conviction in that case, okay? Because we can bring the wife in, right? We can put her on the stand and she can lie. We can impeach her with her prior statements, and then we can ask the jury to consider her prior statements, what she gave to law enforcement, as the substantive evidence in the case and convict the individual. But once again, that's the kind of case where they're going to have a hard time with it. But we want to make sure that we're not letting people who hurt other people, particularly spouses, go, because those are the cases that primarily end up in being murder cases. You know, that down the road, a woman is far more likely to be killed by a spouse than by any other party in any other person in the world. So it's always a difficult thing in determining how to go forward on DV cases. Thankfully, this year we were given another tool from the legislature when they transitioned from the old Georgia Code to the new Federal Rules of Evidence, or a modified version of the Federal Rules of Evidence. Historically, a spouse could incapacitate herself at trial and refuse to testify. So we have a domestic violence case where the police are called out. It's obvious that the spouse has been struck by the wife's been struck by the husband. She gives a statement initially, and then down the road she gets to trial and she refuses to testify. And she can do that. She can refuse to take the stand altogether. If she does that, we can't use those prior statements because the person is not available. They haven't been subject to cross-examination. The Sixth Amendment isn't met. The new code says that we can compel them to testify in domestic violence cases or cases involving crimes of violence against persons in the household. So we can lock her up, if we have to, and we'll do that in certain circumstances, that we will hold them in jail until they're willing to testify. And at the point they testify, if they lie, then we can use all those prior statements as evidence substantively. So we can bring in their prior inconsistent statements, remind them of what they said to the police. They can say that it was all a lie, I didn't say it. But bring it in through the police officer and through whatever records we have, photographs of injuries, those kind of things, and ask the jury to hold them accountable in that situation. Yes, sir.
Have you seen the Williams case that the Supreme Court decided a couple weeks ago on roadblocks instead of really telling?
Was it Williams? I thought it was Brown. But were there? We sent out a brief to all the CEOs of all law enforcement agencies to informing them of how they need to address roadblocks from now on, and how they need to make sure that the separation between the supervisory personnel and the people at the roadblock, not to mix that, not to be out there, to be part of the roadblock if you are the person that designated it, and not to make audibles at the scene of determining where to set the roadblock up or change locations by personnel who are involved in the roadblock itself. So we answer questions when they have them about what to do prospectively going forward, and we're asking them all to update their policies and procedures manuals in light of that decision. Yes, ma'am. Paralegals provide us with a lot of support in terms of assisting us with case preparation, sometimes reviewing briefs, doing legal research. Only one of our administrative assistants actually is a paralegal. We would love to have more. We welcome interns, by the way. And if you want to do some fun stuff, we have some fun things you can do. But our administrative assistant in Madison County is a paralegal, and she does assist in some legal research and review of just case files in preparation for trial. Yes, ma'am. I can give you my card, and you can talk to my office manager, and she can coordinate to set up some a schedule that you can come in and assist us with. It could be a variety of things, but you'll get to see the inside and the inner workings of a DA's office, and it's really pretty exciting. And anyone who's interested in being an attorney, the only way you're going to get to try cases as a lawyer these days if you go to either work at a public defender's office or work at a district attorney's office. So few cases actually go to trial on the civil side that I don't think there's anyone in my law school class who's tried anywhere close to the number of cases that I have. Yes, ma'am. Not a lot. They get LNs in the Navy and make a pretty good living. So the legal men in the Navy are paralegals, and they put you through a paralegal course as you go into the Navy as an LN, and it all goes through Newport, Rhode Island. They have an excellent program up there. But you might have to deploy. 90% of all criminal cases in the United States are resolved by plea bargains. We have resolved about 99% of our cases that way this year, just because of the staff that we have and the resources we have. When we started this year, we had 3,241 pending cases circuit-wide for 5 assistant district attorneys. And that's just, it's impossible to navigate that kind of caseload. But we've managed to bring it down significantly by almost 2,400 cases. We haven't brought it down that much because we've obviously been taking on new cases. But overall, the backlog is down by about 33%. That's all the ones we inherited, with us over 3,000 cases that were pending when we started. Yes, sir.
Some of my criminal defense attorney friends say that there is a tendency, not necessarily in your circuit, but in some circuits, for prosecutors to overcharge as a way of the plea bargaining process in order to get basically what they would have to begin with to a plea bargain by overcharging and overpressing. Is there pressure to do that, or is that, how do you deal with that?
No, it's. We receive warrants from law enforcement, and when they investigate a case, by and large, they attempt to take warrants for every violation of the laws that they can see at the outset. When we receive the case, we can make a determination of which matters we bring forward, and in certain circumstances, we might bring more charges because we're aware of other violations that the law enforcement officer might not have been aware of. But we're not trying to just pile on. What we're trying to do is make sure that we only have one bite of the apple. Double jeopardy, in addition to the constitutional variety, there's statutory double jeopardy in Georgia that if we don't bring everything forward at the appropriate form that are connected in one case, if they could have been brought together, we're barred from ever bringing it forward again for those offenses. So it's not a matter of trying to overcharge, but every violation of law that we can conceive of that is associated with the incident, we're going to charge them for it, if it's practicable and reasonable. Child molestation.
Yeah.
Well, child molestation in Georgia doesn't mean that you have to touch someone. All it means is that you performed an immoral or indecent act to or in the presence of a child. Well, why was he masturbating in the back of a car in plain view of a child?
I understand what you're saying, but the argument that the defense attorney made was that was overcharging. That was not his intent to in any way molest the child.
Well, then that sounds like an issue for the jury, because my argument as a prosecutor would be that the only reason he's doing it back there is because he's looking for this child to stumble upon him, and that's what he gets off on, and that's an immoral act done in the presence of a child with the purpose of satisfying the sexual desires of the accused. And we might resolve it in my office by way of a felony indecent exposure, but we've tried cases like that before. Yes, sir. The one where the 16-year-old was shot and killed and her child died was very difficult. But the one that really stayed with me for a long time was earlier this year, involving a 71-year-old man over in Franklin County who, the defendant was a 39-year-old woman who had some bizarre mental health issues. She was taking methamphetamine, which doesn't help. But she had been institutionalized earlier in the year and then gotten on methamphetamine, and she was coming off of methamphetamine and undergoing a methamphetamine psychosis and ranting and raving, and everyone that she knew, all her friends had kicked her out of their houses because they couldn't control her. She went to the jail to try to get a friend of hers out of jail that she had set up while acting as a CI for one law enforcement agency, and she had nowhere else to go, so she called a 71-year-old friend of hers who owned a number of rental properties, and he had employed her in cleaning up and painting the rental properties. So he allowed her to come over and stay at his house. It was in December of 2011. And the next day she got up and took off all her clothes and put them in bags and walked out to the road and deposited them on the road. He was acting very irrationally. And he was trying to get her out of the cold. It was middle of December, and bring her into the house. And when he did finally get her in the house, he locked the door. And that set her off. The neighbor heard a glass shattering, and he was some distance away working at a barn, and came over and looked at the kitchen window and saw the 71-year-old backed up against a wall and saying, "Call the police, she's gone crazy." When the sheriff's office got there, they could hear her singing from inside the house, "Praise be to God," over and over again. And when they kicked open the door, she was completely naked. She was on top of him, and she was beating him in the face with a metal pecan cracker, and asked the officers to help send him home. She had stabbed him 6 times in the back with a kitchen knife, and the last thing he said when the officer was able to, it took 4 officers to get her under control. She had to be tased multiple times over and over again. And she fought with him, and she's covered in blood. They finally got her off of him. They asked him what his name was, and he said Tommy, and that was his last word. He was transported to the hospital. He died on the way. And she continued to rant for the next hour or so about demons and possession. She was evaluated by 2 different psychologists and found to be not legally insane. She was deemed at one point to be not competent to stand trial, but she was restored to competency. She claimed 2 days later that he tried to rape her. He was fully clothed, had his shirt tucked in, belt buckled. He also had a penile implant that required pumping up in order to actually get an erection. So there wasn't any chance that he actually attempted to hurt her, but she went just nuts and murdered him. And that was very difficult. She was found guilty and got life without parole. It was her claim that he was trying to sexually assault her primarily. Legal insanity means that you have a mental disease or defect that prevents you from being able to distinguish between right and wrong at the time of the offense. So even you can be a paranoid schizophrenic, but if you can distinguish between right and wrong at the time of the act you're committing, then you're not insane for the purposes of the law. Yes, sir. Yes, there is a difference. Well, voluntary intoxication is never a defense. So if you take a substance and it causes you to go bats, that you can't raise that as a defense in a criminal case. I mean, it doesn't matter how drunk you are. If you could have formed the intent to commit the offense while you're sober, you're accountable to the same degree. So that issue doesn't really play in. So alcohol, drugs, whatever it is, if it affects your personality and causes you to behave in a way you wouldn't, you assume the responsibility when you took the controlled substance. But there's also what's called involuntary intoxication, where in the event that you take some sort of prescribed antidepressant or something else that affects you in a way that you weren't anticipating and couldn't have been warned of, then that may be a defense in certain circumstances. Yes, sir. These are concerns I think that we all deal with more than you really expect on a daily basis. And the fact the parole board actually has unfettered discretion to release a person after a certain age, even if they've received a sentence of life without parole. They have the ability to humanitarily release them. in that circumstance. I don't know what the cutoff is. I think it's 70, but they can release them. But people in prison tend to have a shorter life expectancy in general, and that has to do with there are a number of different infectious diseases that people are more prone to in the prison population. But there are all sorts of, there's a confluence of factors we always have to take into consideration in determining what sentence is appropriate, because we have to be able to, one, deter people from committing crime. If people don't believe there are consequences, then that they think that the world is their oyster and they can do whatever they want and hurt as many people as they want. But, and that sounds good up front, but it's not always true, because the fact is that we're not housing drug abusers. But if you look at the breakdown of the prison population, the vast majority of the people in the prisons are violent offenders. With the people who have simple possession rather than possession with intent, we practically never send someone to prison for a possession offense. We work with them to send them through some sort of substance rehabilitation program while they're on probation. And sometimes we'll revoke their probation in the event they commit some sort of subsequent property offense or violent offense, in which case they may be in prison for that. But by and large, drug possession, historically have not been sending people off to prison for low-level drug offenses. That does not happen. It really doesn't. But even people forget. Memories are fuzzy. We've done all this before. In the 60s, there was this big push for rehabilitation because there were too many people in prison, and it was costing us too much. And so we changed the model and started pushing for rehabilitation. So instead of using the criminal justice system to punish people and offer a deterrent and being the force of retribution in society when people break the laws, we went to rehabilitation. And as we did, the violent crime and property crime started to take off. So latter part of the 70s and 80s, we go back to mandatory minimums. We start being the stick again in the criminal justice system, punishing people, putting them away, isolating them. As we did so, prison populations exploded. But over the course of the 90s and 2000s, violent crime and property crime went down across the country. And the reason for that is when you isolate those most dangerous among us, they can't hurt people. So when they're not out on the streets, they're not committing crimes. There have been studies that have shown that it's more cost effective for someone who's like just a recidivist property offender to house them at $30,000 a year than it is to have them out in the population stealing and ripping all the copper out of a house or out of a chicken house or just taking people's stuff. So we're going to swing back eventually. I mean, I know that these drug courts, county courts, there have been a lot of studies that have shown a strong efficacy. But on a long enough timeline, we're going to be back in the situation where the pendulum's going to go in the opposite direction and people are going to want retribution and punishment again.
That's just one explanation.
Sure.
There's economic professor from Chicago who relates to downturn in crime.
Roe v. Wade.
And if you've read his book, there's a lot of statistical analysis and a lot of rationale to it. So we can't always put the
You're right.
effect as simply as that.
I agree. Absolutely. It's a multivariable situation, and subtle changes in initial conditions can result in a dramatically different outcome at any turn. And we can't always know exactly how it's going to play out. But I think my role is clear that I'm supposed to be out there making sure that the bad guys get hammered.
I'm not contesting that that's what prosecutors do. But when I used to practice, there was a building down in Milledgeville called the Washington Building that was full of nothing but older men who were sickly, who were in life sentences. This was before you had life without parole and prison rights things and things like that. And back in the 80s and 90s, there were lots of courts that were putting people away first-time possession of cocaine and things like that. It wasn't until there were so many cases like that that judges started backing off of that, and then it was the second or third time possession of cocaine. So,
Well, we're practically on the way to they've taken down for simple possession. The range now is based upon weight. It's a much lower penalty for each one. It used to be just possession of cocaine, first offense penalty was 2 years to 15 years in jail. Now it's based upon the amount of grams, and it starts off with like 1 to 3 and breaks up. But possession with intent it still has those same penalties as it had before. And proving the intent to distribute is something that we're required to do at trial beyond a reasonable doubt. It can be a difficult thing. I tried a guy for 5 ounces possession of marijuana in 5 separate bags. Thought it was a pretty good case in terms of proving possession with intent within a housing project. Found guilty at trial. Went to prison. Court of Appeals reversed, said I had not proven intent to distribute sufficiently. That's a lot of marijuana for one person, and it's already packaged into 5 separate bags. But whatever. But I agree that there are a lot of different factors that go into it. Yes, sir. Oh, wait, can I say one more thing real quick? Trafficking now, post July 1st of this year, more than 28 grams of cocaine, 10 years in prison, mandatory minimum, no parole. Used to be parolable, not anymore. So. Sure. I tried.
Where do you put your office throughout the rest of your term? What are you trying to do? What are some of the things that you're trying to initiate that may bring changes to the northern district that you want to see happen?
Well, what we've been doing a lot more of is accusing the cases we can accuse rather than taking them to the grand jury. Well, we're not required to bring every case we have to the grand jury, so we're trying to reduce the burden on them and to get cases into Superior Court faster, so we're getting people arraigned faster, getting discovery out faster, and getting cases resolved faster. Historically, the office that I took over, it didn't have, they have 4 offices. They only had voicemail in one of the offices. They required defense attorneys to come into the office and to manually copy the state's file with their own paper from their copiers. And it's just a system that was just built in huge amounts of delay into it. So we've moved to cloud-based discovery furnishing. We have a lot more scanners. We're enhancing electronic communications, and we've gotten voicemail, which is an important thing. So we're working very closely with the PD's office and getting cases resolved early, meeting with everybody well in advance of counter calls, making sure they know what their offers are, and getting as many cases as we can moved, hopefully, so we can get to a point where we're dealing with very recent cases, and that any case that comes in, we'll be able to resolve it in a timely manner and try it as soon as possible if it needs to be tried.
A friend of mine is a DA, and he recently had his salary cut by the county that puts in the amount that the county put in, and ended up resigning. Is there any effort being made to not reconcile, but to have a better funding mechanism for DAs and CPDAs so that it's not a cost-cutting? With all the lawyers out there who said counties see an opportunity to cut their budget by going to cheaper prosecutors.
It's interesting. I wish my counties were willing to give me a supplement because I get paid just my state salary, nothing else. And so I empathize with them. But our office is funded. My 5 ADAs are all funded by the state. So it's myself and my 5 assistant district attorneys. I have 2 assistants that are paid for by the state, and one investigator paid for by the state. I have 2 administrative assistants, one paid by Madison County, one by Franklin County. But we've divvied up the overall budget to put the burden on all the counties for those 2 additional assistants because they actually provide services to all the counties. But when I took over, the counties which are responsible for providing us with sufficient funding to operate were paying us $23,000 a year total to do everything to actually just in terms of like everything, electronics, copiers, toner, paper, telephones, books. We were getting nothing from 5 counties to handle the prosecution of every criminal case in the circuit. So what we're trying to make sure is that the counties know how much we're doing and how important it is to be able to adequately fund us, because if we're not given resources, we end up in a situation where we have to. I would love to try a lot more cases and plead fewer cases if I could. But without sufficient resources and sufficient staff to handle the tremendous volume that we have, and without the funding to be able to make sure that we have everything at our disposal necessary to try cases, we're pushing right now to get an additional person from the counties. I doubt it's going to happen. They fought us when I went before the Elbert County Board of Commissioners and requested that our budget for this year be $20,000 rather than the $10,000 they're giving us last year. They denied me, but they approved the Public Defender's Office budget of $80,000 that they were giving them to defend the criminals, but not even all of them. They only handled the indigent cases. So we're doing our best to inform the community and the county commissions of what we need to adequately operate. My fear is that we're doing everything we can to make sure they know. Right now, I have like when we try cases, we use stuff like this, like a big screen, a projector. The screen and projector are mine. I own them. I bought them myself. I didn't use county resources. It can be difficult at times because we feel like we're doing good work. We're really making a difference. We've changed the way things are going. The former DA's office had a 24% conviction rate against public defenders, so they're losing pretty much everything they tried. We're winning cases, and the message is resonating. People are in the criminal community know that we're coming after them, and they're getting scared. But in order to keep doing that, we're going to have to get them to pony up at some point enough to keep us operating at a reasonable level. It's difficult. I mean, the Georgia budget hasn't increased since the state budget hasn't increased since 1990. Overall, the whole budget, and my ADAs haven't had a step increase. They got one this year for the first time after 5 years. So they're still being paid what they were 5 years ago. Yes, sir.
Mark, I'd like to close with one final question. In our class, it's definitely a hot topic. And my students say, why in blazes does it take so long? Do you ever see that changing in our society where these death penalty cases won't be extended 10, 12, 15 years because people take away
The problem is the system that was put into effect years ago, the Unified Appeals Procedure, was designed to handle all of the appellate issues up front, make sure that the case was tried as tightly as possible, and then when it went up on appeal, that it would be all of the process to the Supreme Court and all the collateral attacks and the conviction would be handled swiftly. All it did was add in more bureaucracy to the whole process and delayed it longer. And the defense attorneys are really winning. I mean, in terms of it's become so onerous and burdensome to try a death penalty case that this is what they want. They want it to be so costly, such tremendous delays to it that finally the DAs just give up and just go with life without parole rather than death. And that's part of the hard thing to do is remember the commitment you have to the community, knowing that the majority of the Americans support the death penalty, and fighting through the expense associated with it to make sure those who have murdered someone viciously and have an aggravating factor are held accountable in the appropriate way. Because there is no deprivation of liberty really sufficient to offset the taking of an innocent human life. It's when the state exerts a monopoly on revenge and the people want the ultimate punishment to be imposed or have the ability for it to be imposed, then the state's responsibility is to utilize that punishment when appropriate.